Hello and welcome to this week's Ask an Attorney. Today we're joined by Meggi Ihland from the firm of Schweiger, Clemeen and McBride. Welcome.
Thanks for having me, Wayne.
All right, let's take a look at our question. The questioner is asking, what does it mean to have a lien on my property? I'm looking into buying my first home and keep hearing this term. So, what are the different types of liens?
Yeah, I mean, this is a great question just in general for this person clearly going into a new, part of their life. I mean, great question. So a lien is typically thought of in connection with real estate. It is a claim against property made by an individual in order to secure payment of a debt. So the lien can be make the property collateral against money or services that are owed to that other person or even an entity. And I'm sure everyone knows what collateral is, but kind of the legal technical definition is an asset that has been pledged by the recipient of a loan as security on the value of that loan. So let's say the person who received the loan is unable to pay the loan later. Well, then obviously the lender will look to that collateral as a source of payment for that.
Okay, so what are the different types of liens? I know I asked you that earlier, but as far as the different kinds that we're talking about here.
So in North Dakota, I mean, they categorize them by general and special, but I like to think of them as voluntary and involuntary. And by that I mean voluntary are those that are created by contract between the creditor and the debtor. So, the lender and the person getting the loan. For example, like right here, the mortgage. So that would be a voluntary lien for that mortgage loan to buy that real estate. So if you don't make your monthly mortgage payments, unfortunately, the lender can repossess your home for foreclosure to get that payment, to get that all sorted. And voluntary liens, on the other hand, are those that are created directly by the homeowner, kind of, I like to say, not intentionally created. So for example, tax liens, construction liens, judgment liens even, and I know we've discussed those in the past, but unfortunately if you get sued and you have a judgment against you, that is a lien on most of your real property. And so just going to kind of the construction lien, because I know that's more prevalent. So that would be, a person would be entitled to a construction lien if he or she improves the property. And whether that can be under contract with the real estate with the owner, or that can be under contract with any agent, trustee, contractor, subcontractor, anyone basically. And that lien will usually attach from the beginning when the services were created, or kind of that first take on when you started improving. So just kind of a real example and, is applicable to this viewer's question. So let's say you pay a contractor to remodel your house or even build you a new house. So what they'll do, they'll get their subcontractors that specialize, they have their certain skills, everything like that. Well, let's say unfortunately, once they start the services, your contractor doesn't pay your subcontractor. So, based on North Dakota law, that subcontractor could then move to get a lien on your property. And what kind of ends up happening is it's a dispute between you and your contractor saying, hey, please pay this subcontractor. I don't want this lien on my house. And that puts a cloud on your title, so you don't want that on there. If you're going to sell your house in the future, you want that title clear and clean and nice. So.
Okay, so how is a lien created or enforced? What's the process of going about that?
Right, so it's called perfection, and it varies depending on the lien, but let's say for this construction lien example, so that person, so the subcontractor in this instance, will record it with the county recorder's office, and that'll be where the property is located. And that has to be within 90 days of when they kind of did everything. And I know homeowners are probably freaking out here thinking, oh my gosh, do I get notice of this? You're supposed to under the law, so if you don't get notice, call an attorney. But you're supposed to get notice within 10 days before they're going to do that. So you're supposed to get it by certified mail, kind of, hey, we have this lien, we're going to record it. And what the recording does in the perfection is just kind of makes it official. If there's other creditors, if there's other liens, it kind of makes it, the priority. So everyone kind of knows where they're sitting in the race, essentially.
Okay, anything else? We've got about 30 seconds. Anything else that you think the viewer should know?
Just in terms of the amount of the lien, so it usually is for, of course, what they're owed, but it can also be, depending if you don't have the contract or if it's something way out of scope, it's going to be for the reasonable value of services. And always make sure if you're filing the lien, it's for the right amount, because under North Dakota law, if you don't file it and the homeowner contests it, you have to pay their attorney's fees and costs. So not good. So.
All right. Thank you so much. All right. Thank you for being our guest today, Meggi. She's Meggi Ihland, and she is from the law firm of Schweiger, Clemeen and McBride. And we do want to give you a reminder once again that not all these are as cut and dried as they may appear. So if you do have specific questions, we urge you to contact an attorney.